Members of the jury, you are the sole judges of the facts in this case, and to those facts as you find them from the sworn testimony in the case, you will apply the law as it is given to you. The burden of proof is upon the plaintiff to establish his case by a fair preponderance of the credible evidence in the case. And by a preponderance of the evidence is meant the greater weight of the evidence, not necessarily the evidence of the greater number of witnesses, but the evidence of those witnesses whom you see fit to believe. Credible evidence is believable evidence, evidence worthy of your consideration. It is your duty, whenever you can, to reconcile conflicting statements made by witnesses or parties on opposite sides of a case, so as to assume every witness is speaking the truth. But if you are satisfied that that is not the case, it is then your duty and your privilege to decide whom of the witnesses you will believe. In deciding that, you will take into consideration not only the interest, if any, of the witness in the result of your verdict, but the demeanor or behavior of the witness on the stand, that is, whether or not the witness answers reluctantly or whether or not the witness answers in a friendly or hostile manner. If any witness has deliberately testified falsely as to a material point in the case, you can entirely disregard the evidence of that witness, but you need not necessarily do so. You can believe the part that you think is true and disbelieve or disregard the part that you think is false. You will not be governed in your consideration of the case by remarks of counsel except as they are borne out by the evidence, nor will you be governed in your consideration of the case by the decision of any motions that have been made to the court. The net result that the decision of any motion indicates is simply that you are to pass on the case as a matter of fact as a jury. The case has been very ably tried by distinguished counsel on both sides, and I don't think you should have great difficulty in arriving at a verdict. I will say at the outset, before starting the charge, that you cannot find a verdict for the plaintiff in this case upon the original contract that the plaintiff claims was made. The question I submit to you is whether there was a ratification of the board of directors of the contract which was made by Mrs. Lind. Plaintiff sues to recover the sum of $5,000 based upon two causes of action. The theory of the first cause of action is that a contract was entered into between the plaintiff and the defendant, which contract plaintiff fully performed, but that the defendant repudiated the same, and as a result of that repudiation of the contract, the plaintiff suffered damages in the sum of $5,000. The other cause of action is substantially the same, except it is based upon the theory of recovery for the reasonable value of the services rendered, which plaintiff claims to be $5,000. It is a familiar rule of law that where a contract is made and the party is unable to prove the agreed price, it may still recover upon the theory of what is the reasonable value of the services. In this case, it is not disputed that the members of the defendant had a meeting called on February 6, 1994, and authorized the chairman of its committee to enter into a contract with plaintiff for $150,000. He was to create and erect a memorial required by defendant. It cannot be disputed that the defendant, through its members, could not bind the corporation, no matter how laudable the purposes of such resolution may be. There is no question here that the members and the chairman of the committee acted in good faith in the belief that the entire membership of the defendant had authority to authorize her to enter into the contract. No such authority is vested under the membership law, and no contract could be made by her to bind the corporation unless the contract was afterward ratified. There is no doubt that the plaintiff did some work. There is not the slightest doubt that there is some value to the work which he performed. But in order to hold the defendant, the plaintiff must carry the burden of proof and establish by a fair preponderance of the credible evidence that the defendant, through the board of directors, made such a contract, or that the board, at any of its meetings, whether it be a regular meeting or a special meeting for that purpose, ratified the action of the members of the defendant.